A very warm welcome to the Dixcart webinar today. We are delighted that you are able to join us. Our topic today is private wealth, getting it right, trusts, foundations and funds. My name is Dan Sampaio and I will be your chair today. Dixcart is an independent professional service group made up of accountants and lawyers with international expertise. Dixcart work with wealthy individuals and their families to help coordinate succession and estate planning and the efficient administration of their businesses and family offices. Dixcart has been in existence for 50 years and are celebrating their 50th anniversary this year. Originally founded as a trust company, Dixcart has grown to help international families manage their succession planning and structuring from 10 offices in 9 jurisdictions. This webinar will include a panel discussion to highlight the most effective private wealth vehicles and structures across the jurisdictions of Cyprus, Guernsey, the Isle of Man, Malta, Nevis and Switzerland. The webinar will end with an open Q&A session. Let me start by introducing you to our panellists. Katrien de Porter from the Dixcart Cyprus office has worked in the fiduciary and wealth management sector in Cyprus for over 12 years and is expert in the use of Cyprus international trusts. Bruce Watterson in the Dixcart Guernsey office manages a portfolio of structures for high net worth clients, acting as corporate director, trustee and advisor as appropriate. We also welcome Paul Harvey, a director of Dixcart Isle of Man. He is a qualified trust and estate practitioner with 20 years experience within the financial sector and has experience covering all aspects of trust and company management. Henno Kurtzer is from Dixcart Malta. Henno is expert in providing international solutions to companies and individuals around the world and specializes in international wealth planning and asset protection solutions for private clients. Next up, we have Beth Lechemenon from the Dixcart office in Nevis. Beth joined Dixcart in 2022 as managing director of the Nevis office, and her experience in the areas of asset protection, trusts and foundations strengthens the private client services available from Dixcart Nevis. And last but not least, we have Christine Breitler from Dixcart Switzerland. Like her colleagues, Christine is also expert in the establishment of trusts and foundations and provides advice on family office and wealth preservation services to Swiss and international clients. I'm now going to start by putting a series of questions to our panelists. Let's start today's webinar with the following question. What is it that drives people to establish a trust, foundation, or a fund? Bruce, can I start with you on this question?
Yeah, thanks, Dan. Hi, everyone. Thanks for the introduction. It's all about estate and succession planning, really. One of the big questions that we get asked is, how do high net worth families hand over family wealth to next generation? Certainly during the pandemic, we saw a lot of people thinking about their own mortality, certainly much more than historically we have seen, and pondering the question on how they might hand over wealth, what sort of structures they might put in place, how those are administered, managed, and how the assets are distributed when they die, because handing over the reins isn't something that people take lightly. So getting the right structure in place is hugely important. The majority of people that have assets to pass on their death will use a simple will, particularly if the assets are uncomplicated and based in their jurisdiction. But with higher net worth individuals, there are often more nuanced and complicated considerations to take into account. For example, how might assets across multiple jurisdictions be gathered, managed, administered and distributed? There might be concerns about the psychological impact of a beneficiary inheriting a huge amount of wealth, particularly if there isn't a trusted advisor in place to help with that transition. There might be complicated or fractious family matters. There may be beneficiaries who, for their own safety, the settlor wouldn't want to inherit a huge amount of wealth. There might be concerns for remote or direct beneficiaries, grandchildren and great-grandchildren who might not benefit from the estate, and so plans put in place to ensure that they can. A person's estate might be financially targeted by an aggrieved ex-spouse, for example, or an aggrieved ex-business partner. So asset protection is sometimes a key consideration. And the list goes on. There might be forced heirship rules to consider. A person might be concerned about what happens in the event of their incapacity. And a simple will simply can't deal with those complicated and nuanced issues. But trust, foundation and funds, increasingly funds, are very useful planning vehicles for dealing with these. In most cases, the structure will be established by a professionally qualified group like Dixcart, who are independent of the family but tasked with acting in the best interests of the family, particularly with regards to any instructions the family may have. So the actual form of the structure that the families choose, whether it's a trust or foundation, is often guided by their own circumstances, where they live, where the assets are based.
Brilliant, thank you, Bruce. And based on that, my next question is, are trusts and foundations still the best structure for asset preservation and succession planning for the world's wealthy? Katrien, can I put that question to you first?
Hi, Dan. Yes, thank you, of course. And the last year and a half has shown actually a spotlight on just how unpredictable life can be, and has as well kick-started the generational wealth transfer for high net worth individuals. So the world is basically changing rapidly, and any ability to strategically plan for the future has been severely compromised. But organizing set plans can, of course, help high net worth families to take back control of their wealth. So it is actually important to choose the right structure in the right place, with the right trusted partner provider to protect and preserve wealth, which where, of course, trust and foundations play a key role. So both trust and foundation offer the ability for families to set out how they would like assets to be held and distributed in the long term. Structures can allow oversight over family assets with appropriate checks and balances over trustees or foundation board members who actually take on the responsibility to look after things in a way that meets the needs of the family involved. If a wealth owner has young children, for example, and the wealth owner dies or becomes disabled, how can the wealth owner ensure that his children will be properly looked after financially, and how the assets will be properly administered? If the children reach the age of 18, is it appropriate that they come into meaningful amounts of wealth? Is a good question to ask. Is it also important for someone to consider the intentions of the deceased or disabled wealth owner regarding how the assets should be administered and distributed? When you compare trusts and foundations to insurance structures, partnerships, corporate vehicles, and other structures that are also sometimes used, trust and foundations are a lot more straightforward in providing the potential for long-term succession and asset protection planning. Actually, they are both essentially living wills, which for the purpose of succession planning and wealth preservation is extremely beneficial. They both offer substantial flexibility whilst the owner is alive, but also when it comes to distributing wealth to beneficiaries.
Thank you, Katrien. And Paul, can I get your thoughts on this as well, please?
Hi, yeah, Dan, thanks for having us. I think the short answer is there isn't a one-size-fits-all anymore. I mean, the changes in the global landscape in terms of taxation and also public opinion mean that high net worth families now need to look at a wider range of solutions. That said, I absolutely echo what Katrina said, that trusts and foundations, they play a key role in high net worth family planning. I think the perception is that, or the public perception is that trusts and foundation structures are purely about tax mitigation, and that's absolutely not the case anymore. It's very much more about succession planning and intergenerational planning for the families as a whole.
Brilliant, thank you, Paul. So I think that this all leads nicely onto our next question: when might a foundation be more beneficial than a trust? Beth and Katrien, can I pass this question on to you?
Yes, of course. Hi, everybody. It's great to be here today. So there are a number of considerations when looking at when a foundation might be more beneficial than a trust. One of these may be that the client's country of residence is a civil law country. For example, civil law countries are more familiar with the concept of foundations, whereas common law countries are more familiar with trusts. Katrien, do you agree?
Yes, Beth, I agree with you. Foundations are effective for wealth management structures, and they're very well known and well understood in civil law jurisdictions. They have a separate legal personality and can enter into contracts, hold property. The fact that foundations are registered may in some cases be considered to be a benefit, since that may offer a greater degree of control or involvement of the founder or family members in administering the structure. In addition, foundations may be better suited as they are separate legal entities for holding, for example, high risk or speculative investments or trading companies.
Yes, exactly. So with that in mind, many clients may wish to retain an element of control when they set up a structure to manage their private wealth and assets. With a foundation, it is possible for a client to sit on the foundation council or the management board, as referred to in Nevis. This isn't possible in a trust, however, as this type of retention of control could give way to arguments of a sham, in that the settlor isn't giving up full control by allowing an independent trustee to administer the trust.
Okay, then on the other hand, it is worth bearing in mind that if you are considering establishing a structure in a common law jurisdiction, trusts can be very valuable. Whilst there may be some small differences between jurisdictions, the key features of trusts are the same. And this, combined with a substantial body of trust-related case law, means that there is a great deal of certainty when utilizing trust structures. Foundations are newer concepts in common law jurisdictions, and at present, there is minimal supporting case law. The tax treatment of trusts is also better understood in comparison to the tax treatment of foundations in these countries. It is also often acknowledged that trusts are easier to establish, provided that the intention of the settlor to create the trust, the subject matter of the trust, and the objects of the trust are all certain, then a valid trust will be created. The trust does not necessarily need to be in writing. There is also no requirement to register the trust.
Yes, aside from Nevis, where there is a requirement to register the trust, that's a slight anomaly. A trust may be more appropriate, for example, if the beneficiaries or settlor move to a jurisdiction where the tax authorities are more familiar with the concept of a trust. In Nevis, we're actually able to establish quite a unique structure, which is known as a Nevis multi-form foundation. This can change its form throughout its life to be that of an ordinary foundation, a trust foundation, or even a company foundation. So it can easily adjust dynamically based on the client's needs. So going back to the original question, there are subtle differences between trusts and foundations, which means one structure may be preferable in certain circumstances to the other. Trusts and foundations differ in a number of important respects, but both can be used to achieve similar objectives. Both can be effective structures to achieve succession planning, asset protection, charitable or philanthropic aims, and both are flexible tools that allow arrangements to remain private. So when deciding which structure to use, each circumstance will need to be considered on its merits, taking into account factors such as the aim of the structure, the country of establishment, and the level of control which is required to be retained.
Brilliant. Thank you to both of you for those answers. I think you've touched on some really interesting points. Now, are there any other vehicles that could also be considered? And Bruce, if I can come back to you on this question.
Thanks, Dan. So Beth picked up on the concept of elements of concern over control, which family investment companies are a step towards dealing with. They're essentially a special purpose vehicle, most commonly a company limited by shares, which holds, manages and directs a family's wealth and their asset holdings. The shareholders of the company are usually different generations of the same family, and the directors are appointed from the pool of shareholders, so the directors are family members themselves. Family investment companies provide that greater element of control that we've just started to talk about, and control is a very common area of concern for high net worth individuals, particularly when we discuss the concept of a trust, where the legal ownership of a family's assets actually leave their control. However, they retain beneficial ownership. So family investment companies are one option. I just end by saying that family investment companies will be tax transparent in the jurisdiction where the family directors are based, and the company may well therefore pay tax, which harks back to Paul's point in that estate and succession planning is often not about tax considerations.
Brilliant, thank you, Bruce. And Beth, what if we consider a private trust company?
So for many years, private trust companies or PTCs have been a preferred vehicle for acting as trustee to a trust for numerous wealthy families. One of the main attractions of the PTC is that decisions relating to the underlying trusts are made by directors who are carefully chosen by the family or may even be family members themselves. There are a number of variants of the PTC which can be limited by either shares or guarantee, or even with separate classes of shares for voting purposes. But careful consideration as to the level of control exerted over the PTC needs to be planned so as not to lead to tax implications or claims of a sham trust, as touched on previously.
Yeah, I'd also just mention private trust foundations as well here, which essentially provide the same solution as a PTC in that they provide a trustee to underlying trusts. With a PTC, the shares have to be held by somebody or a vehicle, which can lead to questions of undue influence, which some families may wish to avoid. A foundation is essentially an orphan vehicle. It's not owned by anybody, so it deals with those issues. Like PTCs, they are very specialised and do require proper advice to be taken. They're not as common as PTCs, but are another way of families to exercise control over the management administration of their family wealth.
Brilliant, thank you, Beth and Bruce. So moving on to our next question. When setting up a trust or a foundation, important factors most definitely include privacy and confidentiality. How private, confidential is the information of a settlor and beneficiaries in the jurisdictions where Dixcart has offices? Henno, we haven't had the chance to come to you yet, so can I put this question to you?
Thanks, Dan. It's a pleasure to be with all of you today from sunny Malta. Well, from all the offices where Dixcart have offices, we offer trust and foundation services as fully regulated entities. In terms of our internal policies, at Dixcart, we have to collect full KYC on the settlor or the founder of the structure, the beneficiaries if known, and the supervisory council. Now, in Cyprus, Guernsey, Isle of Man, and in Malta, the information that is collected is shared with the regulator and is recorded in a register. The register is not publicly available, so there is some kind of confidentiality. However, the information might be shared with the regulator if the regulator is satisfied that the person or individual asking for the information has a valid reason to the information. Beth, in Nevis, I don't know, how's things recorded in your part of the world?
Thanks, Henno. So as you touched on, whilst we as service providers will hold this information, Nevis on the whole does not have a beneficial ownership register, either public or private. So for Nevis trusts, as I mentioned, they do need to be registered, but it's only the name of the trust, the trustee, and the registered address to be submitted to the registry, but no details of the settlor is shared. And for a foundation, the details of the management board or foundation council, the supervisory board, and the purpose of the foundation, plus the address in Nevis, are required to be stated to the registry.
Brilliant, thank you, both of you. Christine, we've not had the chance to come to you yet in Switzerland, which I know is an extremely popular jurisdiction for setting up a trust or for trusts looking to appoint a Swiss trustee. Please, can you tell us a bit more about Switzerland and the registry requirements?
Okay, yes, thank you, Dan. A pleasure to be with you all today. Actually, Switzerland has no trust register at all. Then neither the settlor nor the beneficiaries, the name of the trust or the trustee are registered. The information for the trust is completely private, managed and only known by the Swiss trustee and by the bank if or when the trust has a bank account.
Excellent. Thank you very much, Christine. So moving on to our next question. Paul, perhaps I can come back to you. What should multi-jurisdictional families consider when setting up a trust or a foundation?
Thanks, Dan. Well, the first thing that they need to consider, obviously, is they need to be conscious of their personal circumstances and then very much what they're looking to achieve. Once you've identified those aims, always the next thing to do is to take tax advice specific to your circumstances. It's actually something that Beth and Katrine touched on before, but by way of an example, in the Isle of Man office, we had a very high net worth family who were looking to put some succession planning and asset protection in place. The principal was resident non-dom in the UK, but the wider family were all resident in civil law jurisdictions. Given the treatment, given that the wider family were in the civil law jurisdiction, on first examination, a foundation looked to be the best solution. However, when we looked into more detail, given that the principal is based in a common law jurisdiction in the UK, that actually could have been detrimental to his personal tax. So, whereas a trust structure would have been more beneficial, whereas obviously conversely, a trust structure wouldn't have been the best solution for the wider family. So what we ended up actually doing is putting in place a hybrid structure where we had a foundation was formed with the sole purpose of acting as trustee to a trust. That way, when the principal was examined in the UK, it looked through to the trust, which was obviously acceptable to there. But if in the civil law jurisdictions, family members jurisdictions, they looked through to the trust. So effectively, we're able to keep the wealth preservation, the asset protection in place through just taking that extra time and looking at a solution that works for the whole family.
Brilliant. Thank you, Paul. That's a great example there. And Bruce, what about from your point of view?
Thanks, Dan. I don't think there's really much to add to what Paul's covered there. Certainly, civil law structures like foundations versus common law trusts will depend, as Paul says, on where the family and potentially their assets are located. I'd also echo what Paul says, and we've said before, which is, advice. It's really important to take proper professional advice, which is likely to include tax advice. And in Paul's very interesting case study example there, tax was a main driver. But I would say that tax is often not a main driver in considering succession and estate planning solutions.
Brilliant, thank you. And Bruce, just whilst we're on that, are there any specific considerations that you recommend family offices should be thinking about?
So, yeah, let's start with what a family office arrangement is, because family office is a bit of a buzz phrase. There's a spectrum of family offices that range from single family offices that directly employ professionally qualified staff to work for that family and to only work for that family and with their assets. And then at the very other end of the spectrum are fiduciary groups like Dixcart, who provide professional and dedicated support to manage and administer quite often complicated affairs. I have several family clients, and that's often called multi-family office. Particularly with multi-family office, it's important that families consider things like the track record of who they're working with, the experience that that fiduciary group, those trust and corporate service providers have, how long the supporting group's been around, and also an increasingly common consideration is the ownership structure of that group, whether it's private equity backed, whether it's management owned, whether it's privately owned, because this can have an influence on the level of fees, the level of service, and also the relationship, which is absolutely vital, because that fiduciary group is and will become a trusted advisor to those families.
Christine, I don't know if you have any thoughts on that as well.
Yes, well, to me, it's really important to understand the needs of the client and his or her profile. This includes the jurisdictions where the settlor and the members of the family are based or could be based in the future. I think it's also important to find the right balance between flexibility and security. And this is why a PTC or private trust company should also be considered. I would also say that the jurisdiction chosen to set up the family office is essential and should be in a suitable tax neutral jurisdiction. This is the key of the legal protection of the family office assets and activity. Henno, do you have anything you would like to add to this?
Yes, Christine, thank you. So I think the other thing that we need to consider is the relevant experience of the family office with regards to the specific industries that the family might be involved in, or if they hold any niche assets like super yachts. The question of control also comes into play with regards to family offices and the family wealth. And professionally supported arrangements sometimes require the family to hand over control. And that's where PTCs or private trust companies come in, as what you mentioned earlier, and Beth earlier in the webinar, because that still gives the family some ability to retain control over their assets.
Great, thank you all for those answers. Moving on to Dixcart and how Dixcart can help. Are there any unique aspects of the trust or foundation offerings in your jurisdiction? And Beth, can I put that question to you first, please?
Absolutely. So Nevis has some rather unique aspects to its trust and foundations law. They're quite front-running in comparison to other jurisdictions. So in addition to the shape-shifting aspect of the foundation I touched on earlier, Nevis trusts and foundations also benefit from unique asset protection laws. So if a creditor wishes to bring an action against one of these structures, they must first submit a bond of $100,000 for a trust or $50,000 for a foundation to the Nevis Minister of Finance before the court will consider the action, and no foreign judgments are recognised. There is also a 2-year statute of limitations period for trusts and 1 year for foundations, within which a creditor must bring any action within this time. And all proceedings are held privately in camera, which is in the judge's chambers. So Dixcart can assist with family office services, as Bruce mentioned before. We can act as trustee for trusts. We can provide registered agent services only, secretarial services, and also act on the management or foundation council of foundations.
Well, concerning Switzerland, the Swiss specificity is that Switzerland does not have domestic or internal trust law and applies foreign legislations to the trust formed and administered by Swiss trustees. The settlor then can choose the law of any trust jurisdiction to govern the trust. For instance, a trust based on Guernsey, Isle of Man, or Nevis law could legally be administered from Switzerland by a Swiss professional trustee. Foreign trusts administered by a Swiss or by a foreign trustees have been legally fully recognized since 2007 under the Hague Convention on Trust Recognition.
Brilliant. Thank you, Christine, and thank you, Beth. On the topic of jurisdictions where Dixcart has offices, has anything changed in your jurisdiction, or is anything due to change relating to trusts and foundations? Paul, would you like to comment first?
Yeah, so in the Isle of Man, we had our last major overhaul of trust legislation with the introduction of the Trustees Act 2001. So I think it's fair to say we're due to revisit. So with that in mind, the Trust and Trustees Bill 2022 had its first reading in Tynwald, which is the Isle of Man Parliament, in June of this year. And the bill really aims to sort of further modernise the island's trust legislation and sort of add some certainty and clarity to certain areas. I mean, the bill does propose a series of changes, but there's two probably that are worth looking at first. So the first is the duty to disclose trust information. In this context, trust information is information or documentation, including financial information relating to the trust. And what the bill is looking to formalise is that you can actually hardwire into your trust instrument who can receive that information and also who cannot receive the information. Whereas before you always had to go to court, there's always that option, but this gives you just that more certainty. It also confers the right on certain parties to request information, namely beneficiaries of non-charitable trusts, protectors, again, just providing additional clarity. The second area that they're reviewing or proposing to change, and this is always a mouthful, so it's the power to declare exercise of a power voidable. So who knows? But in a nutshell, what it means is that where a trustee has made a decision, but they haven't fully considered all of the factors or all of the information, and had they done so, that decision probably would not have been taken because detrimental to the trust capital or the beneficiaries. Then it gives the courts the power to void that decision, which is obviously beneficial for the trust as a whole. So that's the Isle of Man. Christine, I think there's some changes in Switzerland, if you want to jump in.
Yes, thank you, Paul. Well, up to now, Swiss trustees were supervised in relation to compliance with anti-money laundering obligations. But the Financial Institution Act from January 2020 requires Swiss professional trustees to be licensed by FINMA from January 2023 to conduct their business. FINMA is the Swiss Financial Market Supervisory Authority. Then Swiss professional trustees will have now to comply with structural, organizational, business conduct and audit requirements. Private trust companies and single family offices are exempt, and the exemption also applies if the beneficiary is a charity.
Great, thank you all. If we now look at funds, an interesting topic and one that is becoming increasingly used for managing private wealth through investments. Bruce and Henno, can I put the next few questions to you both, please? Firstly, why would private clients establish a fund?
Thanks, Dan. So I'd start by saying that funds are globally recognised and transparent investment arrangements, which for ultra high net worth families may provide, interestingly, compliance solutions. So we're working with a family that has a trust-owned investment management business that's based in a European jurisdiction, where the jurisdiction of the overlying trust is on a black or a grey list. And consequently, they have a huge burden of operational compliance work that they have to undertake whenever they enter into new business relationships or arrangements, whenever they're updating existing relationships. By establishing a fund as the ownership vehicle, they cut through and minimize all of that compliance burden. So it's an incredibly cost efficient and effective solution to their particular bespoke compliance dilemma. Families and family offices might also look to establish a fund to deal with all of those elements of control that we've already touched on. Family members might be appointed to the board of the fund investment manager, or indeed the fund itself, which gives better control and oversight by the family directly. In terms of next generation and bringing next gen family members on within the family, mentoring them, they might be the appointed board members, or indeed they might be appointed to look after an underlying class of assets, which would allow for them to be remunerated from the structure, particularly if the assets are doing well. So a whole host of reasons, and I guess I'd end by saying that funds in international finance centres, like trusts, like foundations, tend to be in a tax neutral environment, so you're not adding any additional layers of cost into the management of the family arrangement.
Rizad, I mean, yes, I think also funds are recognized globally. They provide a specific registered, regulated alternative to traditional structures. A private fund might give a more straightforward solution to clients living in a civil law jurisdiction. I mean, I spoke about control earlier, but funds also give a greater legitimate control to the family or the wider family involvement. And there's no real hard definition on family relationships. So it could cater for a wide range of modern family relationships and family dynamics. What's also might be interesting here is that funds do give families or club investors the option to pool their funds together and seek investment opportunities for greater economies of scale. It also gives the investors the ability to unitize specific assets for joint ownership, so like aircraft, paintings, or real estate. And I think lastly, I think to note here is that funds give you a vehicle to hold more risky assets, which might be a problem for a trustee because of their fiduciary duty to consider risks with regards to the beneficiaries.
Thank you for that. And Henno, I'm going to come straight back to you. What are the selling points of your jurisdictions for setting up a fund?
Thanks, Dan. So in Malta, being an EU member state, you have a regulated European fund. We have a very efficient regulator. Once you have a Maltese fund, you have EU passporting rights. Malta's a very stable economy with a positive outlook. From a location perspective, we have a great location to fly in and out of. So if you need to have board meetings, it's easy to get to Malta. In Malta, we have three major funds. We have the Alternative Investment Fund, Professional Investor Fund, and the Notified Alternative Investor Fund. The Alternative Investor Fund is for professionals, qualifying investors, and retail investors. You have the Professional Investor Fund, which is for professional and qualifying investors. And then you have the NAF, which is the quick 2-month fund. So it's really efficient to set up, less regulated, also for private clients. Bruce, what about Guernsey?
Thanks, Dan. So many of the same points that Henno makes with regards to Malta, high quality and robust fund laws, legislation, a very on the ball regulator relating to management administration of funds. In Guernsey, Guernsey funds are able to passport into Europe under the Alternative Investment Fund Management Directive. As with Malta, Guernsey is a tax neutral jurisdiction, which means, as I mentioned before, no additional layers of cost added into the structure. And during the life of the fund, whilst we're on the point of taxes, they'll be paid at the asset holding level throughout the life of the fund, and depending on what those assets are. And also when investors realise their investment, either as an income and capital gain in the relevant jurisdiction.
Thank you very much. And finally, what types of funds are more suited to managing private wealth?
So I'll just jump in here, if I may, Dan. For Guernsey, there are various fund regimes available, so authorised, registered, the private investment funds, which I think were on the previous slide. Dixcart tends to focus on closed-ended funds within that private investment fund regime, which is a regulatory light touch fund option, which is suitable if you have less than 50 investors, which many of the funds which family offices and high net worth individuals look at. What's interesting with the Guernsey regulated private investment fund regime is that once all of the required compliance and due diligence work's been done, these funds can be fast track registered within 24 hours, which is a real selling point.
Yeah, I think in Malta, Bruce, because we've got so many various options, we need to look at the family and what they tend to do. From a practical perspective, the notified alternative investment fund seems to be the vehicle of choice, and I think it's got something to do with the speed at which the fund can be set up.
Thank you, Bruce and Henno. Of course, you've touched on some really interesting points relating to funds there. Now, I have two final questions for you all before we move into the audience Q&A. And then just to say to the audience, if you do have any questions that you want answered, please do put them into the toolbar on the right-hand side of your page. My first question is your choice of trustee, corporate service provider, or fund manager really that important? Christine, can I pass that question on to you, please?
Yes, absolutely. Thank you. Yes, finding the right service provider is fundamental. Dixcart has been providing trustee services and guidance for 50 years, so we are extremely experienced in assisting clients with the effective structuring and efficient administration of trust foundation funds. We have in-house experts and professionally qualified senior employees with a lot of experience, and we are very well placed to support and take responsibility for the trust and act as trustee, providing specialist consultancy services where appropriate. Any individual looking to establish a trust, foundation, or fund should seek a service provider who has this type of experience and can provide that level of advice. You also want someone who can keep you updated with law changes. For example, the UK has recently introduced the UK Register of Overseas Entities, whereby any overseas entity that owns land in the UK since 1999 must register the beneficial owner by the 31st January 2023. Otherwise, sanctions, including fines and custodial sentences, will apply. Your service provider should keep you up to date with this type of changes. To find a proper trustee is not just sourcing someone to set up and undertake the basic administration of the structure. You are looking for someone who has you and your family's best interest in mind and can help manage your wealth and your assets in the best possible way.
Well, I did not agree with you more, Christine. The management of a family's private wealth and assets, and of course the transfer of wealth to the next generation, is for sure a critical issue. A family's financial well-being can be lost or reduced in disputes over control and management of the wealth. And unfortunately, I believe the old English expression "from rags to rags in 3 generations" can often become true. So the ability and understanding of the next generation as to how to deal with the organization and management of the wealth being passed to them is also for sure a vital consideration. So not only do you want a service provider to ensure the structure is set up and managed efficiently, but for sure you also want an advisor who can be part actually of the communication with the family.
Thank you, Christine and Katrien. And now my final question for today, before we move to the audience questions, and I'd like you all to put this. I'd like to put this question to all of our speakers, if I may. What are the long-term benefits of establishing a trust, foundation, or fund? Katrien, can I come back to you to start, please?
Yes, Dan, of course. Thank you. So from a Cyprus point of view, there are several long-term benefits, especially when establishing a trust. Any international trust settled in Cyprus may enjoy the country's tax benefits. So that means basically that all dividends, interest, and royalties received from the trust are not taxable or subject to withholding tax. And in addition, they are also not subject to estate or inheritance tax. No capital gains tax is paid on the disposal of assets of a Cyprus trust.
Okay, to me, trusts and foundations are really the best structures to plan and protect a family's assets. They are like an umbrella from where the assets could be organized, allocated, selected, as well as protected for now and for the future. Their flexibility is one of their best qualities, especially trusts. They are easy to form, they could be changed, and they can protect the beneficiaries in different scenarios and with special needs and in total discretion.
Thank you, Christine and Katrien. Beth, is there anything that you would like to add?
Yes, absolutely. So I think everybody has highlighted several long-term reasons throughout the webinar why trusts, foundations and funds are and continue to remain efficient and highly successful vehicles for managing private wealth and private assets. But one final point is the continuity of having these structures in place, especially after the settlor dies. So this point does not always feature as a client's primary reasoning when families are settling up these structures, but it is important that there is no room for dispute after the settlor passes.
Henno, do you have anything you'd like to add?
Thanks, Dan. I think my colleagues covered everything. One thing I'd probably say here at this stage is that as a group, we do consider all the factors of the family, how they wish their wealth to be managed, protected and distributed to the family when the time comes. All the jurisdictions where we operate out of have each the unique, efficient and beneficial solutions. But at Dixcart, we propose the right solution to the family. So whichever office you contact first, we will assess the client's needs and then recommend the correct office or solution. But as a reminder, we do recommend getting tax advice to ensure that you're tax compliant in the jurisdiction that you're in to benefit from the best tax incentive and benefits that can be attracted.
Brilliant. Thank you, Henno, and thank you to all our panelists today for their very interesting points that they have made. We're going to move on to a quick Q&A session for the next 10 minutes or so. And we have had a few questions that have come through whilst we've been speaking. Our first question relates to Cyprus. Katrien, is a trust in Cyprus directly taxed, or are the beneficiaries taxed under personal income tax law? Is the trustee responsible for all tax declarations?
Thank you, Dan. A trust is not a separate legal person and has no tax obligations on its own. So where assets held by the trustee on the terms of the trust generating income, then this income is taxed as per the tax status of the beneficiary. So the taxation shall be carried out on the basis of a tax residency threshold of the beneficiary. And the Inland Revenue Department here adopts a threefold approach set out in the amending law, where there are only either Cypriot resident beneficiaries, either non-resident beneficiaries, or beneficiaries both resident and non-resident respectively. With regards to the question whether the trustee is responsible for all tax declarations, I can answer yes. So the trustee will be the person responsible for the payment of any taxes due. Also, the maintenance of all the relevant information concerning the trust and its beneficiaries and compliance with AML legislation shall be also the trustee's obligation. The trustee shall also disclose to the Inland Revenue Department anything else necessary, registration of any beneficiary in case that person is a Cyprus tax resident for tax purposes. Also, the trustee will be responsible for registering the beneficiary.
Great, thanks, Katrienne. We have also received an inquiry for Malta. Henno, do you have to use a local trustee in Malta?
Dan, we would always recommend to our clients to use a local Maltese trustee, as the trustee will be familiar with the local regulations and reporting requirements. Having said that, the Maltese law does not require a Maltese registered trustee to be appointed. However, if a non-Maltese trustee is appointed, then there's a requirement that such trust must appoint a qualified person, which in most cases is a Maltese registered trustee.
Brilliant, thank you, Henno. Beth, I have two questions here for you. The first about Nevis. Which structure is more flexible in terms of making changes throughout its lifetime?
Okay, so as touched on earlier, the multi-form foundation can chop and change its form throughout its life. And in addition, existing trusts or foundations can easily be migrated to Nevis as well. So additionally, an existing company incorporated elsewhere in the world or in Nevis already can actually be transformed into a Nevis multi-form foundation as well. So that provides the continuity of its history. So I'd say the multi-form foundation is certainly the most flexible structure within Nevis.
Brilliant, thank you, Beth. And a question from the audience from Brett. Is there a lifetime for the trust or a lifetime for the assets held by the trust in these jurisdictions, i.e. 21 years?
So within Nevis, there's no perpetuity period for trusts, so assets can be held indefinitely until a period of time where they are to be distributed to the beneficiaries, or a trust will fail if it doesn't hold any assets, so then the trust will come to an end. Paul, do you have anything to add from the Isle of Man for that?
Yeah, so in the Isle of Man, following the introduction of the 2001 Trustees Act, the perpetuity period was actually extended to 150 years. Which will outsee most of us. In terms of the assets, the point on the length of time the assets are held, again, as long as the asset remains and the trust has objects within the trust, then there's 150 years. One point which I'd add on slightly on a tangent is that's one of the reasons why having a corporate trustee rather than individual trustees, because you have that continuity through a corporate.
Excellent, thank you, Beth and Paul. This question I will put to Bruce and Henno. At what level of funds do the structures become cost efficient in each location, and how about family companies?
That's a very good question. And it really depends on a number of different factors. So a lot of fund administrators set quite a high bar in terms of the initial target fundraise and the ultimate value of assets under management. And you'll struggle to get a meaningful conversation if you're looking to raise funds that have an initial target of less than 100 million currency equivalent. I mean, we're happy to discuss right down to the sort of 5 million mark. It's difficult to give an exact level at which a fund becomes cost effective because it will depend on things like the frequency and activity at the asset acquisition level and how frequently assets are disposed of as well, how frequently and involved the reporting to investors is, and all sorts of other factors. So difficult to put a number on it, but what I would say is that quite often the costs of running funds is much lower than many people expect.
Bruce, I think for us, we're very similar. In Malta, we're very happy to consider much smaller fund values than the usual go-to jurisdictions for funds. But we would need to assess each fund on a case-by-case basis. But you know what, I'm always happy to have a discussion with clients to see if we can make it work in Malta.
Brilliant. Thank you very much for that. And just looking at our feed, I think that's all of the questions that we've had in from the audience today. So thank you very much for those questions. We will be in touch with you after the event if you have sent a question in after this that hasn't been answered. I think that we'll be able to finish a few minutes early today, but I'd like to thank our panelists who have covered a wide range of aspects relating to trusts, foundations and funds, and covered the fundamental questions to consider not only for wealth management professional advisors, but for the wealthy as well. And most importantly, thank you for attending this event. A recording will be sent to you after this webinar, which will also be available on the Dixcart website. And we will also be sending out supporting articles with additional information regarding each jurisdiction. We hope you have found this Dixcart webinar thought-provoking and informative. Please get in touch if you have any questions or if we've not managed to answer your question today. I hope you do have a good day. Thank you for being with us. Goodbye.